All right, welcome back to the Veterinary Ledger Podcast, powered by Granite Peak Veterinary Advisors. Here, we explore the business of veterinary medicine from ownership and ops to finance, leadership, and practice growth. Each episode, we talk with practice owners, industry experts, and veterinary professionals, giving you real insights you can apply right now. So let's dive in. We got an industry expert here today, Rob Montgomery. I appreciate you coming on the podcast.
Yeah, thanks for having me, Jared. Excited to chat with you.
Absolutely. I mean, you can give a better bio than I can. So tell us a little bit about, the law firm you've created and how you serve the veterinary industry.
Sure. Yeah. So I have had this law firm for 28 years. During that time, I've represented healthcare professionals, throughout the process, but really over like the last 10 to 15 years, the exclusive focus of our practice has become representing veterinarians and dentists with their business, M&A, real estate employment needs. We don't litigate here at all, but we're helping, for the most part, people transitioning into and out of practice ownership, and we do it in many markets around the country.
Talk to me about, I think we should talk on both. I know we try to keep it to 15 to 20 minutes, so we're not going to be able to cover or scratch the surface, but uncovering all the topics today. But if I'm a startup or I'm looking to acquire an existing practice, whether solo and or with a business partner, how do I connect with you? What are the services that I need to be mindful of? Maybe even some pitfalls that you've seen over time that as a practice owner, I can certainly avoid utilizing a service like yourself.
Yeah. So from a starting point, I mean, we do the legal documents. We would help possibly work to counsel on a letter of intent, which is oftentimes the first step of the process where the parties lay out the business terms of what they're looking to do. And then if we're looking at a partnership with a startup, we're going to help with the review and the preparation of the operating agreement, which is really the partnership agreement. And we'll come back to that if I could in a minute. And then we also help with the real estate component. If it's a startup, a lot of times there's a lease review and negotiation or the purchase of the real estate. And if you're purchasing a practice, generally we're looking at an asset purchase where you're buying the assets of the practice. But let's come back to the partnership thing. Especially I feel like in the startup space, Jared, there needs to be a really compelling reason for two people to go into a partnership with a startup. I think there's a lot of challenges with a startup generally, but now all of a sudden when you have two mouths to feed, the challenges become even greater. So, and just take another step back, this is all the legal documentation stuff that we do. We can help put you in position from a legal agreement standpoint where you need to be. But what myself and all of the lawyers always tell our clients, there's nothing that we can do in our legal realm here that can make a bad deal good. And I'm not just saying this because I'm on a CPA's podcast, but the success, an acquisition or a startup really begins and ends with the financial consulting, the tax and the accounting, the business aspects of the deal. And, if you're talking about a startup, we're talking about budget. What makes sense? How much money can you afford to pay and borrow vis-a-vis what you can expect to receive in the early stages of the startup? If you are looking to buy a practice or partner or buy into a practice, cash flow analysis and cash flow projections, where the CPA is helping walk through what, after you borrow this much money, you expect that this is going to be the profit of the business, how much money you're going to have in your pocket at the end of the day. It doesn't have to be and won't be an exact number, but it gives you a range of what you can expect. And if you don't jump through those hoops and do all those things, you're just taking what's behind door number 2. And with these transactions, these projects, you don't get like a do-over after 6 months. You can't give it back. You can't change it. You owe the bank sometimes millions of dollars. And like just telling them like, you know what? Oh, gee, I thought I was going to make more money, or, we borrowed too much money for what we could possibly make. This is where the accounting and the financial planning and the structure of these deals, like I said, it begins and ends with that. For us, documenting this stuff in a way that you're protected legally, I've been doing this for 30 years. That's easy.
Sure.
Every deal is different, but it's crucial that, these numbers are right and they work.
Walk me through because I've heard differings of opinion. I certainly have an opinion. Maybe I'm off base, but I always thought, that LOI, the letter of intent, it provides the frameworks, right? The purchase price, and gives you some basic structure to what the transaction would look like. My thought was always to go through with the financial analysis, make sure you understand the number, then make an offer in the LOI. But I've heard, because it's non-binding, that it's okay to sign the LOI and then go ahead and do your financial due diligence. What do you prefer? Is there a good or a bad? Again, my reasoning for that is I'm setting an expectation with the seller that I'm going to agree to a price before doing the analysis. But I'd love to hear from a legal side, the pros and cons of that approach.
Well, here's the answer. It all depends. So I feel like, in a perfect world, if you have the ability to do all the financial due diligence and submit an offer that you feel good about, that's always best. Because, to your point, while LOIs are non-binding, I hear, brokers, realtors, sellers say this all the time. Don't worry, it's non-binding. Well, that is the deal, and if you try to change the terms, the purchase price or other things, while it may not be a binding contract that one party could sue the other party for not proceeding, changing material terms could kill the deal. So, and if you tell somebody you're going to pay them $2 million for the practice, and then your CPA does the due diligence and says, this thing's not worth $1 over 1.3. Well, that deal's probably going to die, right? But what I would say is that's in a perfect world where you have the ability to get all your ducks in line and then present that offer. If you're in a situation where you're looking to purchase a competitive practice, and when I say there's competition, rather to buy this practice, you may not have the luxury of doing all that first, because you could find yourself saying like, we're working all the numbers. We came back. Here's the number we like. Yeah, we sold that to somebody else, right? So if there is competition for this particular practice, then you may have to just go and submit that offer and then use the due diligence to validate it. And look, worst comes to worst, if it turns out that number is not good and it's not going to work for you, then the deal is probably going to die, but maybe it was going to die anyway. But
understood. And you mentioned the other thing you mentioned, which again, I very much agree with, is there has to be a real strong underlying reason to jump into a partnership from the get-go, right? Let's say we do. Say there's, we have two docs that, it makes sense. They want to move forward with it. How detailed is that partnership agreement? Because, we're going into partnership thinking we're about to spend our careers together and exit off eventually into the sunset, 20 years down the line. But how detailed is it on, hey, if the proverbial shit hits the fan, like what a buyout looks like, for cause, without cause, is those conversations that you really try to have early, even when the feelings and emotions aren't there?
Yes, but there are limitations to that, and I think sometimes people want to know, like, build in the exit strategy to this. And if we didn't have a multi-million-dollar bank loan that both partners have personally guaranteed, there's a lot of things that we could do on paper to provide that. But when it comes to a breakup of a partnership, the bank and that loan that both of the docs have guaranteed, that's what's driving the process. So any kind of document that says like, we could split, we could separate, but there needs to be a mechanism to either pay off the bank or for the bank to release the guarantee of one of the partners. And frankly, most banks aren't going to do that unless they've got other collateral, a replacement guarantor. So there's sort of like, I guess, the final answer with that, Jared, is like, we can do things legally, but practically speaking, we are limited by the fact that, there's this loan. And I think it's important too for people to realize that when you borrow $3 million for an acquisition or startup project or whatever it may be, you borrow it from Bank of America, say, they have what's known as joint and several guarantees. That means each partner is guaranteeing the full amount. So if the bank needs to go after, if there's a default, they sue both partners for the full $3 million. And whoever they get the money from first and they're able to collect from, that's who they collect from. So sometimes people have the misunderstanding, like my half of the loan is this, this is their half of the loan. So I just have to figure out how to get rid of my half of the loan. Like, no, it's one loan that you have both guaranteed the whole thing. And that becomes a practical impediment so that, again, even though there are things that we can put in these agreements, the ultimate ability to separate in that situation is really going to be limited. Now, it changes if you are a much more mature practice, that you don't have debt, then yeah, there's all kinds of things that can be done in counseling that can be done. But that's not usually the case. Usually we're talking about a buy-in, we're talking about a loan that goes along with that. Bank's going to take a lien on the practice assets, or if you're acquiring something. Most partnerships I see too seem to fall apart sooner than later. And because they were somewhat set up for the wrong reason, or they partnered for the wrong reason. You find out pretty soon after that's not going to work. And usually that's after there's been some major lending event, so that there's a big loan out there, which is, not even the elephant in the room. It is everything in the room at that point, and try to navigate that to actually separate in a way that the bank is going to release you and get apart is a real big challenge. So I would say going into these things, you better go into it thinking you're not coming out of it, because you're going to be partners and your hands are tied until, the end of time, basically. And it's really a more intense commitment than a marriage.
That's a great point. You said sometimes. I think if I had to poll practice owners, I would think majority or all the times they feel as though, hey, I'm a 50-50 partner. I'm only on the hook for, 50% of this obligation. And then what would you say? What would your gut tell you if for the partnerships that do, unfortunately separate? Do you think that comes about within 36 months? Is it a 5-year window if a partnership has legs and is going to work out? Or is it that 3-year, hey, this startup was supposed to be, cash flow positive by 24 months. We're at month 36 and we're still running a net negative. And that's when all of the fracture starts to happen.
I'm going to take the under on that one, Jared. Yeah, I think it happens.
Yeah.
I think it happens within the first few years, if not sooner, and
Wow.
you're talking about, like, you've got this debt. You don't really have revenue, or certainly not enough revenue for you both to make money. Like, just like anything, any kind of relationship where you have financial strain, that's going to put a strain on the relationship, whether it's a marriage, a business partnership, and that startup time where, you're just feeling the burden of the debt while you're waiting for the revenue to come in. That's going to, cause cracks in whatever foundation. The other thing is, even if, and that's normally most of these partnership situations do revolve around sort of economic strain, but there's some other things that we see too, where, two people are partners where one partner thinks that buy supplies at Costco, the other partner thinks we should throw a $25,000 holiday party. Nothing wrong with either of those things, but maybe those people shouldn't be partners.
Yeah.
The other thing that we see is sort of like a different, we'll call it a tax strategy. One partner wants to hire all their kids and put them on the payroll, and maybe there's some home improvement projects that seem to kind of make it into their side of the ledger. And you got another partner who wants to dot all the I's, cross all the T's, follow all the rules. I'm not casting judgment as to either of them, but those two people probably shouldn't be partners either.
No. There's a foundational, you disconnect, a divide between how that partnership's going to operate 100%.
Mm-hmm.
Yeah. Now, stick on that partnership, because I think there's a lot there, and I'm certainly seeing a bunch of it, but you pull together a great operating agreement. Do both partners also then need a separate employment agreement, or because, hey, we're 50-50 partners, is really, the employment agreement is just excess?
Yeah, it depends what their CPA wants us to do in that regard. So, if the partnership is taxed like an S Corp, then we're going to have separate agreements. If the partnership, I'm calling it partnership, we're talking about an LLC, really.
Yes. Yep.
And with the LLCs, you could be taxed like a partnership, or you could be taxed like an S Corp. If it's an S Corp taxed LLC, then we're going to have separate agreements. If it's taxed like a partnership, we're going to provide for the professional compensation to be provided for in the partnership agreement or the operating agreement.
Sam, sticking on kind of the startup, and I do want to touch on kind of the exit side of things as well. But is there a timeline where, all right, LOI is signed, that generally the deal comes together within a 60-day period of time, and what else should we be focused on or worried about if I'm buying the assets of another practice?
Yeah, so during that time period, doing due diligence, I mean, the real estate is crucial. That's a variable with all these deals. Or is the real estate being purchased, or are you taking an assignment from a third party landlord or entering into a new lease? The real estate is an important aspect, unless you're planning on practicing out of a van, which some people do, mobile vet clinics, but that's not most of our clients. So the real estate really matters. You can't have a vet office without an office. So making sure that that's locked down and secure, looking at making sure there aren't liens on the practice, making sure that you understand what the arrangements are with employees, getting to know vendors, still looking at the financial performance of the practice, looking at associate agreements, making sure that if it's in a state that has permits, covenants not to compete, you want to see enforceable covenants not to compete that are assignable, and then, coordinating all this stuff to kind of get the information. Because as a buyer, you need to know what you think you are getting. And so an asset purchase agreement, a lot of it is really just representations and warranties, disclosures from the seller. I disclose that I don't have any disputes. These are my employees. This is how much they make. This is their vacation. All that stuff that you want to know when you step into shoes as a practice owner.
I would see that I'm going to take a pivot here for a second, just because, outside of just the startup and acquisition work that seems like, both of us are doing frequently, we're also then having, practice owners wanting to buy and acquire multiple practices. And we're seeing a lot with like that MSO structure where there's a management service organization. I guess, quickly, just, is there anything to be mindful of? When does that make sense to have that extra layer and level? Because I would assume that it's more cost, certainly from a tax and compliance standpoint, but from also, a legal standpoint. When does the MSO make sense? What's the critical document that's needed to kind of solidify that management service agreement between practice and management company?
Yeah. So some of it is state dependent, and state specific. So, if you're in a state that does not allow non-vet ownership of the practice, and you have non-vets who are financially involved in the practice, then you're probably looking at that MSO arrangement for sure, because that's the mechanism to allow those people to provide services for a profit in the business. I guess, other than that, or in addition to that, when, if you feel like there are possibly better purchasing options as being under one umbrella, or may have that you're sharing employees across numerous practices, where you have employee sharing arrangements, it might just be easier just to have one payroll for all 6 locations. And, while it adds an additional layer, it might make it easier to be able to manage the day-to-day and the payroll and bill paying and all that stuff. But the big thing usually with that is just, it's driven by non-professional ownership being involved in the practice. And in those states, it's crucial if you're taking investor money with people that want to be involved in the operation of the business.
Sure. I know we spent most of this conversation on the getting into practice ownership, but getting out of the exit, right? Is there anything foundationally, legally that changes? Obviously there's an asset purchase agreement to start when you're, buying a business, or an operating agreement if you're going into it with a partnership. If I'm now a seller, how does the conversation differ? What type of conversations are you having with that seller? What type of documents are you drafting?
So it depends on who the buyer is. If you're talking about selling to a vet, it's a very friendly transaction, doctor to doctor, a practice transition. Both parties want to see the transition succeed. The buyer is kind of taking on the legacy of the seller. And that's usually a very amicable, cooperative thing. And what I would tell our seller clients in that situation is to focus on the things that really matter. So if you're a buyer, you need all these details. You need to make sure that you're getting what you think you're getting. You're preventing the seller from doing things. The seller, there's a few things that really matter. You're going to get your money.
Sure.
Nothing in there that's going to cause you to lose your money. And the non-compete is consistent with what you're looking to do after you sell the practice. Now, there's some other stuff that comes up, but like that's the stuff that you really need to focus on. And you don't want to get bogged down in the principle of things and like sort of nitpicking things that just don't really matter. The goal is let's sell the practice, then don't, do something to interfere with that. However, if you're looking to sell to corporate, totally different ballgame. Those transactions are much more complicated. The structure is much more complicated. The documents have lots of traps in them, lots of pitfalls. There's not usually a whole lot of transparency in the deal itself. So, making sure that you understand what this means to you from a cash flow standpoint as a seller. After you roll equity in this other organization, you pay taxes, you pay off your liens, you work for them for 3 years. The delta between being an owner and an associate in that situation, how much are you actually getting? And that's where, back to what we talked about at the outset, working with your accountant, and it really has to be a vet-focused account to understand the ins and outs of what these offers are and what they're not. And because, we see so many people that are disappointed after they do those deals, and they're the people that didn't really know what they were getting themselves into because they didn't take all the steps to understand the transaction, the structure of the transaction, the financial implications. Because unlike the doctor-to-doctor deal, these are deals that are set up by the other side to win. And somebody's trying to win that transaction. So there's a winner and a loser, and it's not the corporate group that's going to be the loser in these deals. So it's kind of like on you to get your team together and show up and be ready for the fight. And, it doesn't mean that you can't be friends after, you can't have a pleasant relationship, but it's a totally different mindset. It costs more. It's more involved. Some of these deals get documented more like a $1 billion stock offering than they do the sale or purchase of a vet practice.
Sure. Yeah.
And, they're sometimes they're represented by law firms, large law firms with multiple lawyers. And, they're putting the stuff in there that helps their clients. And when we look at these LOIs that are presented to a lot of sellers, and normally they're unsolicited offers, and they have these giant numbers at the top, and it sounds great. $12 million. What could possibly go wrong? I don't need anybody to tell me whether $12 million is a good deal or not. But Jarrett, it's never $12 million, right? They want you to read
that. But that big bold number looks good. It's a one page. It popped off the page.
Just get drunk on that and just stop reading, and that's what they want, and
100%.
Until you get somebody who can get under the hood with the deal, who knows your practice, to tell you, no, this is what this is. And sometimes, 12 million may not be as good as 4 million, if you understand who the buyer is, what the terms are. And I will tell you too, the transaction costs are much, much more in those deals because frankly, it's just a lot more sophisticated. And while it's the transition or the sale and purchase of a practice, a doctor-to-doctor deal and a doctor-to-corporate deal just couldn't be more different.
Yes, I am so glad you touched on the phrase and the word you use. It's so true. It's like how many times, countless times, because we do that, the after-tax analysis, and you're right. You even said it, like you got to pay off all the debt. Most times the debt related to the real estate as well, because it's all cross-collateralized. And then you have to pay your taxes on the cash you received. And it's like, oh, that's how much money I get today. And then I hope in 5 years, there's appreciation or whatever, depending on the JV that you enter into. Yeah, it's an interesting ballgame.
Well, and the big one with that too, and this is something that I almost feel like sometimes when I walk people through this, it's like I'm doing like a magic trick. They're like, show me again. It's like if you're making, $700,000 a year as an owner, and then you're going to make $200,000 as an associate after, it's $500,000 a year. And if you have to work there for 4 years, that's $2 million. So in addition to all what you just talked about, the after tax, paying off debt and everything, then just lop off another couple mil there. You're still going to work every day. You're still doing kind of the same thing. Maybe, you're not having to solve all the problems when somebody calls in sick or you have an IT problem, but it's a hefty price that's what's hidden, because these people that are buying these practices, their job is they know how to make money, and
Sure.
they're all about making money. And they're oftentimes, they're using the cash flow of your practice to buy your practice. So if it's good for them, really good for them, it's not so good for you.
Understood. Well, Rob, I know clearly what I learned today is, you can run the gamut from the private transaction to the corporate transaction. It sounds like everywhere and anywhere in between. What's the best way for any practice owner to reach out to you and your team? Is it emails, a website? You tell us.
Easy. Our website, yourvetlawyer.com. You can go there and there's a form there you can fill out with your information and just a brief description of what you're looking to do. And my team will get back to you. And usually I'm one of those first calls talking about how we can help and giving you some ideas to how we could work together.
Yourvetlawyer.com. I like that a lot. Man, I wonder what's out there from the CPA realm. I'm going to have to check after we hang up here. Outstanding. Well, Rob, I really appreciate you jumping on it, and certainly want to have you back, because it feels like there's so much we could continue to unpack with everything that you do on the daily. So it's outstanding to know you and have you as an advisor to our clients. So I certainly want to get your name out there as well. So thanks for the time. Appreciate you.
Yeah, thank you. Thanks for all your excellent work, Jared.